He represents clients in transactional matters as well as arbitration litigation. And if you can put aside his Twitter account for the time being, that's at Duris, D-U-R-I-S. I welcome you to speak on federal preemption and state securities laws. Duris Holmes.
You may spend too much time on Twitter when Ed takes your picture from Twitter instead of your firm website to put up on your presentation. When this topic was first chosen, I was happy to finally not speak at a network seminar about pornography. Every time it seemed that I spoke on intellectual property or internet matters, pornography inevitably came up because, pardon the pun, somebody's screwing somebody else over in intellectual property or the internet. After reading all the cases for about the past year or year and a half on federal preemption of securities, I'm not sure this is much better when you read about the Bernie Madoffs, the Alan Stanfords of the world, and what they've done to literally screw over tens of thousands of people. The focus here is on the federal preemption of state law claims, and this arises from the fact that after the Private Securities Litigation Reform Act of 1995 was passed, surprisingly, some of your plaintiff's attorneys are smarter than the average plaintiff's attorney and decided to plead only state court claims to avoid having to be removed to federal court under the PSLRA. As a result, the Securities Litigation Uniform Standards Act of 1998, or SLUSA, was passed, which says that no covered class action based upon the statutory or common law of any state or subdivision thereof may be maintained in state or federal court if basically it involves securities fraud in connection with the purchase or sale of a covered security. The result was that you could, and the statute specifies that any claim that attempts to assert a covered class action based on securities fraud could be removed to federal court and also could be dismissed. The litigation has focused on this issue of what is a covered security. SLUSA has a specific definition for covered security. Basically, A is anything listed on the New York Stock Exchange, American Stock Exchange, or NASDAQ. B is anything listed on a national securities exchange that has requirements similar to New York Stock Exchange, et cetera. And then any security that's equal in or superior to, in seniority to one of the securities described in A or B. The question still became, first of all, the Supreme Court dealt with the issue of do you have to be a purchaser or a seller of a security, as you do in 10b-5 generally, to bring a claim that would be covered under SLUSA, or more appropriately, to have a claim precluded by SLUSA that otherwise could have been actionable. In the Dabbitt case, Merrill Lynch versus Dabbitt, the Supreme Court said, no, you do not have to have a plaintiff that is a purchaser or seller. You simply there has to be the deception of an identifiable purchaser or seller, and the fraud must coincide with the securities transaction. Whether it's the plaintiff engaging in the securities transaction or not, you just have to have a coincidence of the securities transaction. That led to a split in the circuits. You've got 7 circuit courts since Dabbitt have addressed this coincide requirement and have come up with various variations on what does the coincide requirement mean. The Second Circuit has said it has to necessarily allege, necessarily involve, or rest on a securities transaction. The Fifth Circuit has adopted the Ninth Circuit, and I'm going to discuss that in detail because that case is going to be the first case heard in the next Supreme Court term. Adopted the Ninth Circuit approach. The Sixth Circuit has the same approach as the Second Circuit. Seventh Circuit says it has to be involving a securities transaction. It has to mean more than but for the sale of a security, this fraud could not have occurred. Eighth Circuit says it's related. Ninth Circuit, more than tangentially related to. 11th Circuit, induced by or dependent upon. In 2012, the Fifth Circuit decided the Rowland versus Green case, and the Supreme Court has granted writs in that case. The case arises from the Alan Stanford alleged Ponzi scheme. I say alleged Ponzi scheme only because it's been beaten into me that it is alleged, because we represented one of the defendants in the, I believe, 3 class actions or actions pending in the state of Louisiana. We removed, initially what was going on here is that Alan Stanford was using an Antiguan bank called Stanford International Bank to sell certificates of deposit, which of course were not really certificates of deposit. And if you consider what securities that were alleged to be invested in, unless you consider cricket fields in Antigua, robbing bank officials, private jets, et cetera, to be securities, he wasn't investing in anything. What he was doing is to sell these CDs in Latin America primarily, and to ExxonMobil retirees and some others in Louisiana. What happened is he would, of course, guarantee rates that were 8%, 9%. Surprisingly, the plaintiffs that I've talked to never thought that was unusual that you could be guaranteed 8 or 9% rates, of course, but they invested anyway, and some of these people literally invested their life savings in what they thought would be stable CDs. They took their ExxonMobil stock, put into the CDs, thought they were set for retirement. And what has happened is that, as the 2008, 2009 financial crisis came about, Stanford was robbing Peter to pay Paul. He was taking having to redeem these CDs that were earlier, and then not able to fund later CDs. And it all collapsed in February of 2009 when the SEC took over Stanford Investments and put it in a receivership in Dallas. The plaintiffs, there were 3 suits filed in Louisiana. Actually, there were some more, but 3 that we're primarily going to talk about. And then a suit filed in Dallas involving the Latin American investors. We removed 2 of the cases under SLUSA. The Dallas case actually was filed and based in federal court by the plaintiffs asserting that there was jurisdiction under SLUSA. The 2 cases in Louisiana we removed, and then they were MDL and transferred to Judge Godbee in Dallas. The plaintiffs moved to remand the Louisiana suits. All the defendants moved to dismiss the 3 suits. Judge Godbee considered the Rowland versus Green case as kind of a test case to determine whether SLUSA applied and whether he was going to dismiss the actions or remand them. When Judge Godbee looked at the issue, he said that he found 2 reasons to find that this coincided with the purchase or sale of a security, specifically of covered securities, and he adopted the 11th Circuit's approach. The first was that the purchase, there was a misrepresentation made to these plaintiffs, as the plaintiffs had alleged, that the reason that such high rates could be paid is that the funds were being invested by the bank in securities of governments, institutions, et cetera, paying high rates. The other reason that Judge Godbee found that there was jurisdiction is that SLUSA applied and there was a covered security was that the plaintiffs were induced, a large number of them, to sell covered securities in order to buy the CDs. As I mentioned, that there were ExxonMobil retirees that liquidated their retirement funds and had a lot of ExxonMobil stock in them to buy these CDs. Based on that, Judge Godbee denied the motion to remand, granted the motions to dismiss. Last year, the 5th Circuit heard and decided the case and rejected Judge Godbee's decision. It applied instead the 9th Circuit case. I recommend the Rowland case to you as a good exposition of all of the cases that the circuits had decided, because it is, the 7th case in 7th Circuit to decide it, and the case that is going to the Supreme Court. And it rejected the attempts by the other circuits in part, and specifically he rejected, I think, 3 of the circuits, because they did not attempt to define the coincide requirement. Instead, they only discussed what above and beyond coincide was sufficient. And reading between the lines, basically one of the problems you have here is that these cases tend to be fact-intensive. There's been little guidance other than this coincide requirement. And frankly, the circuit courts that have looked at it have simply decided on a case-by-case basis whether or not there was a coinciding with a securities transaction. The Fifth Circuit discussed, in addition to the various coincide requirements that had been developed by the circuit courts of appeal, the three different approaches that the courts had taken. There was a product approach, a separation approach, and a purpose approach. And basically the question was, is the product like a security? In that case, it was a product approach. Is there a separation between the product and the investment? That was a separation analysis. And then what was the purpose that was intended here with the transaction? And without saying so, Judge Godbee had basically taken kind of a product approach and a purpose approach as he had looked at the fact that, well, this product, you have a specific liquidation of a covered security, so that's a product. And then on the basis of the other issue of whether or not, what was the purpose? Well, you had the purpose. These people were being told that they were going to be that the CD money was invested in marketable securities. Instead, the Fifth Circuit took the Ninth Circuit approach, and the Ninth Circuit had said that a misrepresentation is in connection with the purchase or sale of a securities if there's a relationship in which the fraud and the stock sale coincide or are more than tangentially related. And the Fifth Circuit had focused on this tangential relationship and found that the heart, crux, and gravamen of this whole fraud by Allen Stanford was not the purchase, was the purchase of CDs and was not the purchase or sale of securities. The case did not depend upon convincing investors to sell SLUSA covered securities, the court found. There's some reasonable questions to be raised about that, because certainly without the money that Allen Stanford gained from the sale of the ExxonMobil securities, you wouldn't have had money for the investments in the CDs. However, you had this broad-reaching CD-based scheme that also took into account other investors that had nothing to do with retirement funds, these Latin American investors who are straight purchasing CDs. So the Fifth Circuit essentially found, when you take everything into consideration, and again, largely a fact-based scenario, that you don't have a situation in which this whole scheme depended upon the purchase or sale of securities. It was based on a scheme involving alleged CDs. The Supreme Court, again, has granted certiorari specifically on the issue of whether SLUSA prohibits private class actions based on state law only where the alleged purchase or sale of a security, a covered security, is more than tangentially related to the heart, crux, or gravamen of the alleged fraud, which takes that language from the Fifth Circuit opinion on tangential relationships and the heart, crux, or gravamen, and really focuses on that. And that will be the first case argued in October. The interesting side note on these cases, one of the cases that was filed in Louisiana we could not remove. We're co-defendants with the Louisiana Office of Financial Institutions, which would not consent to removal. So while this case was going on in Dallas and through the Fifth Circuit, we actually had a class certification hearing in the other case in Baton Rouge, and a class was certified. The plaintiff's attorney fancies himself smarter than your average plaintiff's attorney and decided to name as co-defendants the insurance companies under the direct action statute in Louisiana. As a result, the insurers said, okay, well, we're removing to federal court based on the Class Action Fairness Act. So that case, despite a class having been certified, is now back before Judge Godbee while these other cases are pending. And the plaintiffs are trying to say, well, we don't care if you ultimately win in the Rowland case, because in your particular case you were remanded, and our position is there's no jurisdiction. You have to go back to state court no matter what. So the case is far from over, but the Supreme Court will give us some resolution as to what the connection, the coinciding with requirement that it established in Dabbitt does mean. I've listed a few cases. In the written materials, you'll find pretty much all of the cases that have been decided since January of last year that I've listed out. A few of note that involve the specific issues of whether they did find transactions with covered securities. The Hidalgo Velez case was an example of that applied I believe it's the Second Circuit approach, and found that in that case there were two things involved that merited the coinciding requirement being met. one of which was easy. Some of the funds actually invested in securities, so there never should have been any issue. But the other was that the marketing materials advertised that funds would be invested in securities. Now, this is something that I don't believe the Fifth Circuit would have found to be in connection with the sale of securities because of the fact that it had rejected a similar argument that misrepresentations were made about CDs being sold. But that is an example of the approach that was taken and actually coincided with what Judge Godbee did. Another case of interest, Lakeview Investments, LP versus Schulman, of some interest because of the distinction that the Fifth Circuit recognized between the Ponzi scheme that Alan Stanford ran and what Bernie Madoff ran. And basically what you had a couple of things. Madoff was advertising this approach of a split strike conversion method that he was using to determine what securities to invest in. And you had what were called feeder funds in this case, and the defendants in that case were involved with one of the feeder funds to Madoff. And the whole representation there of how the whole thing worked was that this money would be fed to Madoff to invest in securities using this split strike conversion method, so that you had a specific situation in which the alleged transactions and securities that were going to occur were part of the scheme. And then the other fund involved in that case mimicked the Madoff fund so that they were all intertwined. The last case was the tolling case in which Standard & Poor's was sued because they had their rating was used in an offering circular by which Fannie Mae issued a rated stock. Again, that was found to be because you had a specific offering of a stock that was sufficient. Even though Standard & Poor's wasn't selling anything, wasn't buying anything, it was in connection with somebody else's sale or purchase. The only case really, we've talked about this, the Rowland case that did not find there to be covered securities, it has generally been a standard that is pretty easily met, was Rowland versus Green. I'm going to touch quickly on the National Securities Markets Improvement Act of 1996, only because there really are not a lot of recent developments in that. The NSMIA has a similar requirement that covered securities be at issue with some similar definitions. They are more specific in listing out what is involved, and specifically the intent of the NSMIA is to prohibit states from imposing conditions upon the use of covered securities. And in other words, they can't come up with regulations to override the equivalent of Regulation D type transactions involving securities. And they list out the federal covered securities that are included with some similar, almost identical definitions as SLUSA, and then they add on some Investment Company Act of 1940 requirements and some additional ones that are listed there and listed in the materials. I do have a few regulatory decisions listed in the materials in one case, but there's nothing of any moment particularly compared to SLUSA. Thank you.